All right. Well, good morning, everyone. We are on the record in the 53rd Circuit Court for the County of Presqu'île. We are providing public access both in the district courtroom in Presqu'île County and also online via live stream. I'm appearing from the Sheboygan Circuit Courtroom by video, as is Mr. Mason appearing by video from the Department of Corrections. Mr. Mason, can you hear me, sir?
Yes, sir.
All right, let me know if you need a breakout room with your attorneys at any time. We're here for oral argument on the motion for new trial in People of the State of Michigan versus Justin Ray Mason. It is file number 21-93168FC. Counsel, please state your appearances, beginning with the people.
Kenneth A. Radzabon on behalf of the people.
Angeles Manassas from the State Appellate Defender Office on behalf of Mr. Mason.
And Gabrielle Barber from the State Appellate Defender Office on behalf of Mr. Mason.
Okay, good morning. And again, thank you all for the excellent briefing. And we've had a couple rounds of briefing, and we've had an evidentiary hearing in this matter with some very interesting legal and factual questions. And Ms. Manassas, this is your motion. Go ahead with your argument.
Yes, Your Honor. I believe the intent today is just to give closing arguments, and then if the court has any questions, then defer to that, or is that the plan?
Yep.
Okay. So Your Honor, I think it's important before kind of diving into the substance of the closing argument, just to, as Your Honor acknowledged during this hearing and had just acknowledged now, this is a unique set of questions. In my career, I've never had to deal with this set of facts before. I don't believe that Your Honor has. I don't believe the prosecutor has. So this behavior, however, is incredibly concerning by an attorney, particularly in a capital case where someone is doing a 25-year mandatory minimum. And so that's the first thing I wanted to, remind the court of when viewing this issue. I'll focus my closing just briefly on what the court basically asked us to supplementally brief. First, that on the question where there really is no binding Michigan case law, and we've had to look to circuit case law, whether the stage of trial for which Mr. Wisely was absent, those jury questions and deliberations were a functional stage or critical stage of the case and of trial, and whether this constitutes a chronic violation because due to his intoxication, he was grossly impaired and therefore functionally absent during this time. This is structural error under chronic. Again, there is no direct case law point in Michigan, but the Sixth Circuit has held that jury re-instruction is a critical stage where where it's more than just a re-recitation of the instructions. And here we have that. Here we have a situation where not only the jury asked about particular facts in the case, whether Mr. Mason had shut the door or not during a specific instance, that although the court did respond with rereading an instruction that was already given, had counsel not been functionally absent, it is possible that that question could have been addressed in a different way. But even more important is the issue of the deadlock jury. And they indicated that they were able to reach a verdict on some counts and not on others. And this is similar to Sixth Circuit case law, French v. Jones, where it was held that when counsel was absent when the judge gave a supplemental instruction to a deadlocked jury, and counsel was not given the opportunity to respond there because of their lack of presence, that was held to be a critical stage of the case. And so that was held to be a chronic violation. Of course, here we have a different set of circumstances. Counsel's absence was due to his gross impairment and not due to his physical absence from the courtroom. However, it's still the same, given Dr. Simpson's testimony at the evidentiary hearing concerning how Mr. Wisely's intoxication would have affected him once he administered a 0.15 on the BRAC scale, how that would have affected him at trial, including gross impairment of his motor skills.
Can I ask you, does it make a difference in the French case that you relied on in your supplemental brief? The deadlock jury instruction was sort of a non-standard supplemental one that the jury indicated a deadlock, the standard Allen instruction or deadlock jury instruction is given. And then there was another indication of deadlock, and then the judge gave a non-standard instruction. And I don't necessarily disagree at that stage that there's a lot of discretionary analysis. There's a lot of factors and variables that go into that at that moment. But that didn't involve the first indication of deadlock and a giving of the standard instruction. So would giving the standard deadlock instruction constitute a critical stage in your judgment, and why?
Yes, Your Honor. I believe in this case, it would have constituted a critical stage of the case because that was not the only possible response to a jury who has been deliberating for 3 hours. Had Mr. Wisely been of his right mind at the time, it's possible that he could have asked for the jury to have been voir dired as to, what counts they were disagreeing on or what counts they weren't. A different type of supplemental instruction that did not meet the parameters of the standard Allen instruction. At that point, even could have asked for a mistrial. All of these things are on the table. And so this was not the only response that could have possibly been given by Your Honor and the court to this particular jury question. But since counsel was functionally absent, we don't know what reasonable counsel would have done in that situation. And as the prosecutor makes note of in their first brief, or in their first brief that we filed prior to the Skinther hearing, this jury was deliberating for a significant period of time. At the time, it was 3 hours. This was not a jury that, was in and out in an hour. And so it's clear that they put a decent amount of thought into these very serious charges. And so there was other possible recourse for this particular question. And so, yes, in this case, I do believe it was a critical stage.
So can I ask you a different way as I'm thinking about this as well? Under the old People v. France case about a judge's ex parte communications with a jury, housekeeping matters are fine. That happens a lot. Administrative communications are less are looked upon, a little less favorably, but there's no presumption of prejudice. And substantive communications, totally ex parte between the court and a deliberating jury, there's a presumption of prejudice, but it can be overcome. And giving like a deadlocked instruction is considered an administrative communication, not a substantive communication. So if this court had not even asked to have counsel back, I mean, that's not my practice. I think I take a dim view of that. But if that had been what I'd done, and wouldn't we be analyzing this under People v. France? And why would there be any prejudice to Mr. Wisely if I'd given these standard jury instructions to the jury's questions without even asking Mr. Radzabon or Mr. Wisely to come back into the courtroom? Would that have resulted in a new trial, and why?
Your Honor, that would have been concerning potentially for other reasons, because when you're dealing with a jury who is deadlocked, that is a point where the parties are welcome back to say, okay, how do we address this? Do the parties, obviously it's going to be the court's ultimate decision as to what instruction to give, but that's more than an administrative matter. That is a jury that's potentially deadlocked and can no longer deliberate further, or simply needs the Allen instruction to have that guidance to continue deliberating, or whatever the case may be. And so that's a substantive point in the case. And again, although we don't have binding case law directly on point with this fact scenario, we do have circuit binding case law that says that particular stage, as long as it's not a mere re-instruction of the jury. For example, in Hudson v. Jones, I believe is the case where it was just a mere rereading, of the aiding and abetting instruction. And that was held to just be a very perfunctory administrative type thing. The parties did not need to agree on what that instruction was. It had already been given and agreed to. And so here we have a different situation.
Okay, thank you. You can continue.
Second, Your Honor, I'll move to the second issue here, which is that the instance
Hang on a second. Hold up. We seem to have lost the 89th District Courtroom.
Oh.
So we'd be talking to each other, but not making a record.
That's not ideal, Your Honor. Oh, there we go.
All right, hang on. Are we back in the district courtroom?
I'm sorry. Yes, we are back. So
What
we had a disconnect.
Did you miss anything?
Just briefly. It was Miss Meneses was speaking about agree to what the instruction was.
Okay, if you want to kind of finish up your last thought, Ms. Meneses, and then continue thereafter.
Yes, simply this was, distinguishable from an administrative matter. This was not a cursory rereading of instructions that the parties had already agreed to, which is what the court held in Hunson v. Jones was not a critical stage. This was beyond that because here we're dealing with a deadlock jury, which French v. Jones made note of was a critical stage, given that the jury could either be hung or may need to continue deliberating.
Okay, thank you. You can continue your argument.
Yes. As to the second issue, when Mr. Wisely elicited an instance of bestiality by my client or alleged bestiality by my client from the complaining witness, this was a violation of Strickland. It is ineffective assistance of counsel, and it was prejudicial to Mr. Mason, and thus a new trial is warranted. There was no reasonable strategy for this. As Your Honor put it, this was not such an obviously fantastical story. Like something happened in a spaceship, I believe is the example Your Honor used at the Ginther hearing, that this could have been considered reasonable strategy. This was something that is entirely plausible. Animal abuse is an instance of something that happens many times. It happens with a lot of people. And so it's a real crime. And so it's not something that's so obviously fantastical that it can't be believed by a jury. And Mr. Wisely did not consider the very strong possibility that the jury would hear that testimony and not only believe it, but hold it against Mr. Mason.
But can I ask you, even if and I think it's clear from my comments at the last hearing that I tend to agree with you that that was not reasonable, a reasonable strategy for Mr. Wisely to pursue. But in that, we're looking at the Strickland standard and the prejudice and the effect on the verdict. In order for that testimony to have any effect at all, the jury would have had to believe that it was true, and it was offered through the victim herself. So in order for the jury to believe the bestiality claim, the jury had to believe the victim who testified about the sexual abuse. So how can this result in the prejudice to Mr. Mason that would, under Strickland, say there'd have to be a reasonable probability of a different result?
So as Your Honor instructed the jury, they were able to believe some, none, or all of the complainant's testimony. And it is unclear here, obviously, we cannot parse directly whether the jury chose to believe the complainant's testimony in the totality or whether it was maybe on the fence as to whether or not it believed believed her as to the allegations in the instant case. But certainly hearing about a different type of abuse than was alleged in this case, this was abuse against an animal, would certainly sway a jury because as due to the case law and the secondary sources that we cited in our brief, it shows that animal abuse does tend to paint an individual as a bad guy, someone who is more likely to have committed different kinds of offenses, let alone sex offenses. So it is even more dangerous in an instance where there is a sex crime alleged against a child. And here we have an instance of abuse alleged about an animal, especially one that is a household pet. And so all of these things, it's possible that the jury, this tipped the scales for them if they believed that Mr. Mason was culpable of this type of animal abuse to the extent that his trial attorney would extensively cross-examine and question and elicit this incident from the complainant, which in a way comes across as an endorsement of this, saying, well, yes, it did happen. Let's question, let's go through it, let's ask about it, drawing more and more attention to it. And then, as Your Honor said at the end of the hearing last time, did not even bring it up in closing argument. And so it wasn't even relevant at all to the case. All of these things make this particularly prejudicial to Mr. Mason and warrant a new trial.
When I think about the prejudice prong of the Strickland analysis, when the victim was testifying about that, she said on page 116, and then he told me if I didn't watch, then it would happen to me. So I had to watch. So when the victim was describing it, she kind of tied it to his pattern of terrorizing and abusing her. So although certainly if the prosecutor had tried to bring this in, I wouldn't have let that happen. But once the defense attorney is getting it in, when I'm thinking about the effect of the prejudice, the way that it came in through the victim doesn't entirely lack probative value, does it? I mean, because it's entirely possible that a perpetrator could utilize. In fact, this occurs in domestic violence situations all the time, where violence is committed against a pet in order to exert domination, power, control, or terrorizing of a domestic abuse victim. And in the same manner, to terrorize or exert power, dominion, or control over a sexual abuse victim committing sexual violence against an animal and saying, you must watch this or I'm going to do this to you. So it does have some probative value as well. Not so much, I'm not saying that it would pass a 403 admissibility standard. I'm not saying that. But when I'm looking at the effect on a verdict under a Strickland prejudice standard, should that have any bearing in the analysis?
No, Your Honor. And that does go, somewhat to the 403 issue that you just mentioned, but that's incredibly important here. That sliver of probative value, if any, is substantially outweighed by prejudicial effect here. And so all of the things, including the intense description of the emotional effect that this had on not only the complainant, but the dog, that went in extensive detail during trial. All of those things make this substantially more prejudicial than probative. And so it's more than enough to overcome that possible sliver of probative value.
Okay, thank you. Is there anything else you want me to know about your argument?
No, Your Honor.
All right, thank you. Mr. Radzimod, the people's response?
Thank you, Judge. I guess I'll address it this way. Much of the complaints of ineffective assistance and how that impacted the jury, I want to go back to the sequence of the jury verdict here. After some deliberation, they send out a request for some evidence, a specific question. Did the defendant testify or admit to shutting the bedroom door? That request and that consideration of evidence would have only related to count 3, the CSC third, which occurred later in time than the very first assault testified to by the victim. And this ties in and makes sense, therefore, of the deadlock jury instruction, because they didn't have an answer to that first question. Then they send in the request saying we're deadlocked. We've agreed on some counts, but not on all. And my argument here is that it's much more plausible that the jury had already agreed on a guilty verdict for counts 1 and 2, which dealt with the incident when our victim was under 13 years old, and were hung up on counts 3 and 4. And I say that makes sense because they ultimately came back with the guilty verdict on all 4 counts. So understandably, Mr. Wisely should not have been late. He should have been there. And he certainly shouldn't have been drinking after he left the courtroom, following the close of proofs and instructions to the jury. But I really have to seriously question what impact that had on the jury. I really don't believe it had much of an impact at all. And as I argued in my final argument here, this court, all the case law that discusses these issues, is at a critical phase. Is it a chronic violation? All of those cases stress that the whole record has to be viewed in addressing these and addressing whether there was ineffective assistance of counsel. The whole record, going back to the very start of the trial. And viewed in that light, I guess it's our contention that the impact on the jury was minimal, if at all. And I've cited some cases here in the closing argument. But one of the cases in terms of the prejudice for this bestiality testimony was People versus Mateo. That's a Michigan Supreme Court case. In that case, the court allowed in extrinsic evidence of a defendant's assaultive behavior, and the court said, well, that clearly is error, but it was harmless in view of the overwhelming evidence of defendant's guilt. Again, reviewing the whole record. So my argument to you is that if you review the whole record of this trial, the evidence that was brought in, the victim, her physician, other witnesses as well, I believe that's what the jury was focusing on, and not some claim of bestiality, not some concern that defense counsel wasn't there when questions were asked.
All right, thank you, Mr. Radzimod. Ms. Meneses, any rebuttal argument?
Yes, Your Honor. Just very briefly, I believe that Your Honor can get there to the new trial grant with this Strickland violation under bestiality first and foremost. However, we can't just look at this stage of jury questions as something perfunctory, something that maybe the jury was only concerned with count 3. It's not clear. We don't know what the jury did after they issued that question, and then Mr. Wisely was not present, and so they had to return back to the jury room for a certain period of time while they either continued to deliberate, waited to ask another question, waited for Mr. Wisely to return. It's not clear whether they then returned on their own, relied on their collective memories as to that particular question, and then proceeded. We don't know what counts they were hung on and what counts they were decided on. And so that's what the crucial stage is here. Moreover, I disagree with the characterization that there was overwhelming evidence against Mr. Mason. This was a one-to-one credibility contest. We have no witnesses to the alleged incidents that happened here. We have what Mr. Mason is saying, and we have the complainant's version of events. That is what we have. We have no other testimony or no other witnesses to any alleged abuse that happened here. And so in that situation where you have evidence painting the person on trial as someone who is bad, someone who would commit animal abuse, someone who, you know, they must have committed this type of sex abuse if they've committed that type of sex abuse, this is particularly dangerous. And so I believe not only was this objectively unreasonable performance, but that it reaches the level of prejudice required by Strickland. But even without that, we do have a chronic violation here because due to the nature of questioning and the possible responses that could have been given, and the dialogue that happened between the jury, the parties, the court, this was a critical stage of the case. And so it is a chronic violation as well.
All right, thank you very much. As I said, there's been really good briefing by both sides on these points, and we've had an evidentiary hearing and really, I think, made the kind of record that ought to be made about this question. It's important. Presenting a fair trial is important to people. It's important to the confidence in the judicial system and the rule of law. There are undeniably aspects of defense trial counsel's behavior in this case that are troubling. So troubling, in fact, that this court filed a grievance with the State Bar of Michigan, and disciplinary proceedings are ongoing for that attorney. But trials are not contests in which the better performing lawyer wins. There are real things like evidence and testimony under oath. A jury looks a witness in the eyes and assesses their credibility. For that reason, when we analyze claims of ineffective assistance of counsel, we look not only to whether counsel's performance was reasonable, but we consider what effect any deficiencies in that performance had on the actual outcome. This is because granting a new trial requires setting aside a jury's verdict, which should not lightly be done. And in this case, there are two asserted deficiencies of trial counsel. First, counsel's consumption of alcohol. Initially, I'm not persuaded by this record that counsel was drinking or intoxicated during the proofs or argument during the trial. Mr. Wisely testified at the Ginther hearing that after the jury retired to begin its deliberations, he consumed alcohol, and a fair amount of it. This is consistent with the court's observations of a change in Mr. Wisely's demeanor when he returned, and it is not contradicted by the testimony of the defense expert at the Ginther hearing, who acknowledged that a bolus or large consumption of alcohol in a short amount of time could have resulted in Mr. Wisely's PBT reading when booked into the jail after the verdict was returned. So the question is what to do when a lawyer consumed alcohol to the point of intoxication after the jury has retired for its deliberations, but before it returns its verdict. I mean, I share defense appellate counsel's concern about that. I mean, frankly, I think the prosecutor probably is concerned about that as well, and the court certainly was. That's troubling behavior, and Mr. Wisely will have to answer for that behavior. But we have to think, well, what do we do about that for this trial? Under the Strickland v. Washington standard, we look to the prejudice, if any, to the outcome. And here, under that standard, the jury was completely unaware of any alcohol consumption. Mr. Wisely made no argument or statements in front of the jury after he consumed alcohol. The only thing that happened was that the jury submitted two questions, each of which the court answered by reading standard jury instructions. Had Mr. Wisely not consumed a single drop of alcohol, precisely the same instructions would have been given in response to the jury's questions. Therefore, I'm convinced on this record that his alcohol consumption and intoxication had zero effect on the outcome of the verdict. So under the Strickland standard, the first allegation of ineffectiveness, I think, would not warrant a new trial. Defendant argues that we should instead assess the issue under the US v. Chronic standard, which says that the complete absence of counsel at a critical stage requires reversal without regard to the prejudicial effect. First, was counsel effectively completely absent? This is unclear as there's no binding authority on this point. Here he was in fact present, and the issues to be addressed were rather straightforward. The jury submitted 2 questions. The appropriate response was pretty clearly dictated by the standard jury instructions. This wasn't a situation, for example, where counsel had to make nuanced decisions about how best to cross-examine a witness or what argument to present to a jury. So I'm not entirely sure that his alcohol consumption rendered him completely absent given the situation, although by no means am I endorsing that behavior. But in any event, even assuming that a chronic situation applies here, the court's giving 2 standard jury instructions in response to the jury's questions, I do not believe was a critical stage. The receipt of the verdict itself, I think, is not a critical stage for purposes of ineffective assistance of counsel analysis. That goes back to People v. Williams for 47 Mishap 392 in 1972. And answering straightforward questions with standard jury instructions is also not a critical stage, even under the Sixth Circuit precedent relied on by defendant. In French, for example, the court gave a non-standard supplemental instruction to a deadlocked jury after the standard deadlocked instruction had previously been given. That's not what happened here, where the court only gave the standard instruction. Another way to analyze this issue would be this. Sometimes courts respond to jury questions without even consulting with the attorneys. This is not a recommended practice, but it sometimes happens. And then on appeal, the question is whether that requires reversal. Here, if this court had given these straightforward standard jury instructions in response to the questions, I do not believe reversal would have been required. The first question was, the jury asked, did the defendant admit to shutting the door when he went into the room? Of course, the court can't answer this question yes or no. That would invade the province of the jury. So the court simply reread the standard instructions about the jury's role to decide the facts of the case. The second question was, if we are hung on one or more of the counts and reached a decision on some, what's next? This indicated that the jury was having trouble reaching a unanimous verdict. So the court gave the standard deadlock jury instruction. Under People v. France 436 Mich 138 at page 163 in 1990, this would not have required reversal, even if this had been an ex parte communication between the court and the jury. In France, the Michigan Supreme Court said, quote, administrative communications include instructions regarding the availability of certain pieces of evidence and instructions that encourage a jury to continue its deliberations. So this court concludes that these standard instructions would be considered an administrative communication, which carries no presumption of prejudice. But even if it were a substantive communication, the standard is this under France at page 163, quote, substantive communication encompasses supplemental instruction on the law given by the trial court to a deliberating jury. A substantive communication carries a presumption of prejudice in favor of the aggrieved party, regardless of whether an objection is raised. The presumption may only be rebutted by a firm and definite showing of an absence of prejudice. Here, where the standard instructions were given, nothing the court said to the jury would have caused prejudice to either side. So, if reversal would not be required by these instructions, even if they'd been given by the trial judge ex parte without bringing the attorneys back into the room, the fact that defense trial counsel was factually present but intoxicated, I believe, is legally irrelevant to that question. So accordingly, even though that conduct is troubling, a new trial is not required for counsel's alcohol consumption after the jury began its deliberations. The second issue is defense trial counsel's introduction of evidence that defendant was accused of sexually assaulting a dog. This evidence would clearly not be admissible under MRE 403, as its probative value would be substantially outweighed by the danger of unfair prejudice. If the prosecutor had sought to introduce the evidence, I would not have allowed it. But defense counsel elicited the testimony and articulated on the record that it was for a specific strategic reason. Namely, Mr. Wisely said that he wanted to show the jury that it shouldn't believe the victim's claims of sexual abuse because she also made other clearly ridiculous accusations against defendant. I do not believe that this was a reasonable trial strategy, because it's not as though the victim was making some fantastical claim that would be outside the realm of possibility. Bestiality is criminal and repugnant behavior, and there was no good reason to have that accusation presented to the jury. Additionally, as I articulated at the last hearing, the record shows that Mr. Wisely never even actually made that argument to the jury. He never said, for example, you shouldn't believe the victim because she also made this ridiculous claim about bestiality. So I agree with the defendant that trial counsel's eliciting this evidence was objectively unreasonable. But again, we must address this under the Strickland standard for actual prejudice to the defendant. In other words, is there a reasonable probability of a different result if counsel had not elicited this testimony? In this case, I do believe the answer is no. The reason is this. The testimony about the bestiality was introduced through the victim herself. It's not as though trial counsel elicited this accusation from some other witness, which would have introduced a prejudicial allegation into the case that could have, for example, bolstered the victim's accusations of sexual abuse. Rather, under these facts, in order for the jury to believe the testimony about bestiality, the jury would have had to believe the victim herself, who also testified about defendant's sexual abuse of her. And although bestiality is repugnant behavior, it is not more repugnant than sexual abuse of a child. And under these circumstances, there's no reasonable probability that the jury would have disbelieved the victim about her claims of sexual abuse if only that same victim wouldn't have mentioned another accusation that she witnessed defendant commit bestiality. For these reasons, the second allegation of ineffective assistance to counsel also does not warrant a new trial. Accordingly, defendant's motion for a new trial based on ineffective assistance to counsel is denied. I do have your proposed order that I can date and check the box denying it and sign it and file it if you wish, Ms. Meneses, and then you'll get a copy of it and can proceed with further review of this issue.
Yes, Your Honor, thank you. And I would just like to note for my client, Mr. Mason, I will set up a video visit with you at a later date to discuss next steps. So we won't need a breakout room.
Okay, thank you. All right, anything further from the people?
No, Judge, thank you.
Okay.
No,
anything
Your
further
Honor.
From the defense? Okay. All right, have a good day, everybody.
Thank you,
You
Judge.
too.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Tyson Arnold. It's case number 2024 CR 424. Amber Norris appears for the state of Kansas. Gail Jensen is defense counsel. Tyson Arnold appearing in the office of his attorney, all by Zoom. This matter comes before the court at this time for evidentiary preliminary hearing. Mr. Jensen, is your client still requesting an evidentiary hearing?
Yes, sir. We're ready to proceed.
I trust the state is as well, and the state may call their first witness.
Your Honor, state calls Sergeant Sean Stove.
All right. If he'll come on the meeting fully. All right, thank you. If you raise your right hand, please, the court will administer an oath. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right. You may question the witness.
State your name and occupation for the record.
Sean Scove. I work for the El Dorado Police Department as an officer.
And how long have you been in law enforcement?
20 years.
And how long with El Dorado?
almost 2 years.
Okay. And were you working in your capacity as a law enforcement officer on November 6th of this year?
Yes, ma'am.
And um, how does that date relate to this case?
So the date of this case was when Miss Glover reported that she had a past domestic issue involving Tyson Keith Arnold.
Okay. So the incident didn't happen on November 6th. That's the date of the report to your department.
Correct. That is the date that she filed the police report.
Okay. And who is she?
Miranda, she is the I don't know if you would call it girlfriend, ex-girlfriend at the time to Mr. Arnold, which they also have a child in common.
Okay. And it's Miranda Glover.
Yes, ma'am.
Okay. And the date of the incident that she reported to you on November 6th.
She told me that the incident took place on August 3rd, 2023.
Okay. And can you explain to the court what your understanding of the incident was and what let's start with that.
So on November 6th, approximately 3:30 in the afternoon, I got called to Miss Glover's place of employment, which is the 900 block of Country Club Drive in El Dorado, Butler County, Kansas. Miss Glover wanted to file a past domestic battery case against Mr. Arnold.
Where did this incident, the August 3rd incident, happen?
She said the incident happened at the 900 block of Country Club Drive because on that date she got into a vehicle with Mr. Arnold, and that's when this incident started.
Okay, so it started at her work here in El Dorado.
Roughly in that area when she got into a vehicle with Mr. Arnold.
Okay. And then what happened?
Miss Glover informed me that she had her cell phone with her and began recording an audio file. She ended up sending me this audio file in 2 sections because of the length of it. It wouldn't come through in an email. And overall, this audio recording was approximately 14 minutes long. Throughout this recording, you could hear a male that she identified as Mr. Arnold screaming and yelling at her about Glover filing for the PFA against him. In the audio, you can hear throughout several occurrences during this 14 minutes where Miss Glover said that she was hit by Mr. Arnold, whether it was with a fist or slapped with a PFA that he had just been served against her. Throughout this whole time, he's telling her to shut the fuck up. It's going to ruin his relationship with his daughter. It's going to ruin things for him. In several occasions after you can hear what appears to be a slap or a hit, you can hear Miss Glover crying. She says, ow. She tells Mr. Arnold to stop. Mr. Arnold is wanting her to drop the PFA. At one point in time, she finally gives in and tells Mr. Arnold that she'll get the PFA dropped, and Miss Glover tells him that he did not intimidate her. She said to Mr. Arnold that she would go to the courts to get the PFA drop. She would tell them that she lied about this during this entire 14-minute span of this yelling and screaming going on towards Miss Glover. During this time, she informed me she was in the front passenger seat with Mr. Arnold as they are driving around in the city limits.
Okay. And your understanding, do you know the PFA that she's referring to?
I believe I do. I don't recall the date that it was filed.
Okay. And so you talked to Miss Glover and you listened to the audio file. And did you have opportunity to talk to Tyson Arnold regarding this?
I attempted to talk to Mr. Arnold.
And what happened?
So I seen Mr. Arnold at the Veterans Day Parade there in El Dorado on November 11th of 2023 as he was walking from Central back towards into an alley behind his apartment where he was living at the time. I informed him that I needed to speak to him about a past case that I was working from August, and he told me I needed to speak to his attorney.
Okay. And you knew who Mr. Arnold was?
Yes.
Okay. Is that from previous encounters?
I don't recall specifically dealing with him in person, but I was aware of who he was.
Okay. And did he identify himself to you at the time when you talked to him on November 11th?
No, by that time I was already familiar with who he was, so I did not need him to identify himself.
Okay. And the person that you talked to, and that you know as Tyson Arnold, do you see that person on the screen today?
Currently, at the moment, no.
Okay. Do you just see me because I'm the one that's most recently speaking?
No, I'm assuming he's with Mr. Jensen, but all I can see is an elbow in a red shirt. So I'm assuming that's him, but without actually seeing him, I can't tell you if it's him or not.
Okay.
Move this
Very, very good. I think they're kind of having him move a little bit. I'm not sure if that helps you at all. I assume, are you on your phone?
Yes, ma'am, and I can see Mr. Arnold. That is him.
Okay. And he's and you identify him as the person next to Gail Jensen in the box?
Yes, in the red hoodie.
Okay, thank you. Your Honor, I ask that the record reflect that the witnesses identified the defendant.
The record so reflects.
Thank you, Your Honor. And in regard to this case, after you spoke to Ms. Glover and reviewed the audio file and attempted to speak to the defendant, did you interview any other persons regarding this this incident?
No, ma'am. It was my understanding that it was only Miss Glover and Mr. Arnold present during this incident.
Okay. And it was also your understanding that basically the entire incident occurred in a vehicle that was driving around the city of El Dorado?
Yes.
Okay. Nothing further at this time, Your Honor. Thank you, Sergeant, and stay tuned. Mr. Jensen may have some follow-up questions for you, okay?
Yes, ma'am.
May I ask questions if you have them, Mr. Jensen?
I do, thank you. Officer, on if I understand this correctly, it was on November the 4th of 2024 that you were contacted by Ms. Glover about an incident that had happened in the past, correct?
No.
Please explain. When was the date you were contacted?
November 6th, 2023.
Okay. And she was then reporting to you about an event that had happened on August 3rd of 2023. Is that right?
Yes, sir.
Okay. Did she explain to you Any reason why she had not contacted you on August 3rd or within the next day or two?
Yes, she did.
And what was that?
She doesn't have faith in anybody at the police department because in the past they have just looked at her reports and she felt like they've been brushed away. She is or was in fear of Mr. Arnold because of the continued abuse that she's been put through over the years.
Over what number of years are we talking about? Did you get that information?
I did not get that information, and she did not specify.
She just used the term over the years, so you describe it in similar fashion.
Yes,
Is
sir.
that correct? Did Ms. Glover give you any indication that before either August the 3rd or November the 4th of 2023 that a child in need of care case had been filed involving the child that the two of them share?
Objection, Your Honor, relevance outside the scope of direct also.
Mr. Jensen, relevance here?
The purpose of the case that was filed, the child had been residing with mother, and the desire of the mother to paint the father as an ineligible placement is at issue here.
I don't believe it is an issue. The objection is sustained.
Did Ms. Glover give you any indication that there was any kind of ongoing PFA litigation?
I knew that prior to this that there had been PFAs, but they had always gotten dropped.
Did you assume that the witness status that you attribute to Ms. Glover was in PFAs and not in a child in need of care case?
I'm sorry, can you rephrase that for me?
Did you assume that the witness status that you attribute to Ms. Glover was PFA only?
I guess I'm not understanding your question, Mr. Jensen.
In what case is Ms. Glover a witness? The charge here is intimidation of a witness. In what case is she a witness?
From the active PFA that was on file at the time of she said the incident took place.
Okay. And you assumed that, or did she tell you that?
She said there was one on file. I do recall looking up the information and finding it. I just did not reference the PFA case number in my report or get a copy of it.
Did she mention any other litigation involving herself and Mr. Arnold?
No, she did not.
Did she indicate that they had a child?
Yes.
Did she indicate the primary residence of that child?
No, I don't recall that, and I don't believe I asked the status of that.
Did you consult with anyone other than Ms. Glover about the primary residence of the child?
No, because the child was irrelevant to the case that was being reported to me.
So the long and the short of it is you talked to Ms. Glover, listened to a recording that she had made, and that was basically the investigation.
Yeah, the 14-minute audio recording that I got, and I attempted to talk to Mr. Arnold, and he did not want to talk to me.
And we've now covered everything, every bit of investigation you conducted. Is that right?
Yes.
Thank you. Nothing further.
Any further questions for this witness, Ms. Norris?
Just one, Sergeant, do you have your affidavit with you? Or did you just have a chance to review it prior to the hearing?
I reviewed it, but I can pull it up real quick. I've got it in front of me.
Okay. On the first page, second paragraph, is that the PFA that you've been referring to?
You'll have to get specific with me, Miss Norris. Do you know what bullet point it is? Because I don't have a page break.
No, it's page 1, number 2. Is what I'm
Oh,
telling
number 2, yes. Yes, ma'am.
Is that referencing the PFA that you've been talking about this whole time?
Yes, ma'am. 23 DM 295. I apologize.
That's okay. And did you understand that case came out of Butler County?
Yes.
Okay. Nothing further, Your Honor. Thank you.
Anything further along those lines, Mr. Jensen?
No.
Is there any reason why this witness cannot be excused at this time, Ms. Norris?
No, Your Honor.
Mr. Jensen?
No.
Very well. Scove, you can stay with the meeting. If you do, please mute yourself, or you can leave it at your choice.
Thanks, sir.
State have further witnesses to call.
Your Honor, State would call Miranda Glover.
All right, if she'll come on the meeting fully. Raise your right hand, please. The court will administer an oath. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Very well. You may question the witness, Ms. Norris.
Please state your name for the record.
Miranda Glover.
And Ms. Glover, what is your relationship with the defendant, Tyson Arnold?
Ex-boyfriend, and he's my daughter's dad.
Okay. And on August 3rd of 2023, what was the status of your relationship with the defendant?
Girlfriend.
Okay, so you were
Yeah.
still together on August 3rd of 2023?
Yeah, in a way, I guess. I don't know. Yeah.
Okay. And had you been living together at that time?
Yeah. I don't remember. Yeah, I don't remember. I don't remember.
Okay. And did you file a PFA 23 DM 295 against the defendant?
Yes.
And was it your understanding that he had been served on August 3rd of 2023 with that PFA?
Yes.
And why was it your understanding that he had been served?
Because he came to my work and beat me with it.
Okay. Tell me what happened.
I got off work. Well, he kept blowing my phone up and I was ignoring him. And then he was at my work when I got off. And so I walked to the car and I get in and he starts screaming at me, like and beating me with the PFA. And I kept begging him to stop and he wouldn't stop. He just kept getting worse and worse.
And what is happening? Is the car in motion? Are you driving around here in El Dorado?
Yes.
Okay. And what is he wanting you to do about the PFA?
To drop it.
Okay. And did he, you said that he was hitting you. Was he hitting you with the physical paper of the PFA or something else?
With the paper, and he was hitting me with his hand.
Okay.
But paper, yeah.
Anything else? I didn't mean to cut you off there.
Oh, no, you're fine. Yeah, he was hitting me like with his hand and with the paper, the PFA.
Okay. And about how long did this go on for?
Like 30 minutes.
Okay. And did he normally come and pick you up from work?
Most of the time, no, but there was times that he would, but he wasn't like around that time. He wasn't picking me up. I'd be walking. So yeah.
Okay. So instead of walking, he picks you up and then you're driving around for, you think, approximately 30 minutes?
Yeah, because he wouldn't let me out of the car. Once I got in, he wouldn't let me out of it.
Okay, and did you ask for him to stop or to let you out?
Yes.
And was he, you said he was hitting you with his hands and the paperwork. What else was he doing? What was he saying? He was going to do other things, or what was going on?
He said that, yeah, I don't know. I was provoking him. He was gonna fuck me up if I didn't drop the PFA, and that I was coming in between him and Kinley, which is our daughter, and like and straight threatening me and just scaring me.
Okay. And at this time, how old is your daughter?
Right now she's 3.
Okay, so at this time she would have been what? Probably about 2?
1.
One.
think.
Okay.
Yeah.
Okay.
1 or 2. Maybe she just turned 2 or about to turn 2. Yeah, she was still 1.
Okay. And did you guys stay pretty much in the city of El Dorado when all this was going on, or was he driving further than that?
Further than that, and it was like towards the lake way is where he was going.
Okay, but still always within Butler County?
Yes, in Butler County, yeah.
Okay. And based on what was happening, were you concerned for your safety?
Yes.
And we previously heard from Sergeant Scove. You reported this in November, but this event happened in August. Why the delay in the reporting?
Because he always beats me. He always would beat me, and I was just scared for my life. If I were to tell on him, that he would hurt me worse than he already hurt me at the time. Like he seriously used to beat the crap out of me all the time, and make threats that if I turn him in, then he'll whatever he'll like. I sent those also over to Scope, so he has like proof of that where he'd be saying stuff like that. So that's why I was just too scared to tell.
Okay. And can you see multiple people on the screen, or can you just see me?
I just see you, but I can scroll over, I think, and see everybody.
Okay, would you scroll through and tell me if you see Tyson Arnold, the person that you've been referring to?
No, I mean, I think he's with Gail Jensen, but I don't see him. I just see his attorney. Yep, that's him.
Okay, and could you just briefly describe what he looks like or what he's wearing?
Red hoodie.
Okay. Your Honor, I would ask that the record reflect that the witness has identified the defendant.
Record again so reflects.
Thank you, Ms. Glover. I don't think I have any further questions for you at this time, but Mr. Jensen may have some follow-up, okay?
Okay.
You have questions for this witness, Mr. Jensen?
Yes, sir.
You may proceed.
Ms. Glover, on August the 3rd of 2023, you were at work. Is that right?
Yep.
Where were you working?
Mission Health.
And you had been at work how long?
Until I got off work. I was like from 3:30 when I went to work, and I got off about 8 or 9. It just depended on. I really don't remember how long.
You were aware or notified in some respect that Mr. Arnold was going to be served with a PFA that day, correct?
I'm sorry, what?
You were notified or learned in some fashion that Mr. Arnold was going to be served with a PFA that day, correct?
I don't remember if I knew exactly which day he'd be served, but I knew he was going to be served it, but I didn't know exactly which day he'd be served it. But I knew he was gonna get served it.
Okay, and he was going to come pick you up from work. Is that right?
I honestly don't remember. I don't believe so. I really don't remember.
That was a common experience, wasn't it?
Sometimes he would pick me up and then sometimes he wouldn't pick me up. So I really didn't know.
Obviously, your daughter was not with you at work.
Right.
With Mr. Arnold, if he came to pick you up, where was she?
At Carlene's, um, her Carlene's house.
Who's Carlene?
It's her Nini. It's her Nini. It's her, she has two dads. She did have two dads on her birth certificate. It's his mom. It's the guy that was on the birth certificate's mom that was claiming her as his kid.
You took some steps to anticipate there would be something occurring between you and Mr. Arnold that you wanted to record.
Objection, Your Honor, relevance.
The objection is overruled at this time.
What does that mean? Sorry.
You can
You
answer
may-
the question, please.
Okay.
If you can.
Okay. Okay. Will you repeat that?
On August 3rd of 2023, Mr. Arnold came to pick you up from work.
Mhm.
You placed your telephone in a mode where it would record in anticipating there was going to be something that you wanted to preserve as a recording, correct?
I don't know. Are you asking why I recorded it? Why I would record it? Because I recorded it because I already knew what he was gonna happen to me. Because he always would beat me. That's why I recorded it. And at the time of the PFA, I still had my daughter. The sync case didn't start until after I filed the PFA.
What case are you talking about?
The sync case. The sync case.
Is that the case that,
Child in need of care.
pardon me?
The child in need of care case.
Now, this is the case where you were determined to test positive for
Objection,
methamphetamine.
Your Honor, relevance.
Objection sustained. Counsel, let's go into a direction that's relevant to the case, please.
Were you under the influence of methamphetamine on August?
Objection, Your Honor, relevance.
She had
Moment,
testified.
just a moment, just a moment. At this time, the court will overrule the objection. State the question fully, Mr. Jensen.
Were you under the influence of methamphetamine on August the 3rd, 2023?
Objection, Your Honor, again, relevance.
Objection overruled. Witness is directed to answer.
Yeah.
From the time you were at work until you left work?
I don't know. I don't want to answer your question. Because
Well,
that's to this.
Are you finished? I understand you don't want to answer that question. I have a duty to ask some questions. How long before the time you met Mr. Arnold had you used methamphetamine?
It was before work. It was like before work.
So it was in the afternoon. Is that correct?
Yeah, possibly. I don't remember the exact time, but it was before work.
Had you done anything regarding use during the time you were at work?
No.
And the time you met Mr. Arnold after work was what, if you recall?
If what?
At what time did you meet Mr. Arnold after work?
Objection, Your Honor. Asked and answered. Twice, I think.
The objection is sustained.
Do you recall telling the officer investigating this case anything about your use of methamphetamine that day?
That's irrelevant to this.
And Your Honor, state would agree. Objection, relevance.
Next question, Mr. Jensen.
Does the use of methamphetamine cause you to have a differing perception of the occurrences around you or your recollection of them?
No,
Not at all.
no.
Okay. That's all I've got.
Any further questions for this witness, Ms. Norris?
No, Your Honor, thank you.
Very well.
Oh, actually, one follow-up, Your Honor. Just real quick. Miss Glover, you made a recording and gave that to law enforcement of the incident in the car that we've been talking about, correct?
Correct.
Okay, thank you.
You're welcome.
Nothing further, Your Honor.
Mr. Jensen?
No.
Very well. You have further evidence to present, Ms. Norris?
I do not, Your Honor. Other than I would ask court take judicial notice of Butler County 23 DM 295, which is the DFA case that we have been referencing.
Very well. Mr. Jensen, does the defense intend to present evidence at this hearing?
No.
The court, having considered the evidence in this case, finds that the state has shown probable cause that the crime of aggravated intimidation of a witness or victim has been committed and that the defendant, Tyson Keith Arnold, committed it. The defendant is bound over for trial on that felony charge of the information. The court also finds that there are still pending misdemeanor charges in counts 2 and 3 as well. Having bound the defendant over and found probable cause, the court will proceed to formal arraignment at this time. Mr. Jensen, does your client desire the charging document to be read to him?
Your Honor will acknowledge receipt of the charging document, waive its formal reading, enter a not guilty plea, and request a jury trial setting, please.
We'll accept the plea of not guilty on all charges and establish appropriate jury trial and pretrial conference settings. Also, I'm currently contemplating jury trial setting Tuesday, April 8, 2025. Starting at 9:00 a.m. in the morning, unless announced differently later. April 8, 2025, 9:00 a.m. for jury trial. Court will establish a pretrial conference for the week before. Mr. Jensen, I'm currently looking at Tuesday, April 1. Your schedule that day, sir?
It's open.
Very well. The court will set the pretrial conference for 10:00 a.m. that morning.
Judge, we have a 10 o'clock. We could use 11.
All right. 11:00 a.m. on Tuesday, April 1. For the purposes of the pretrial conference, Mr. Arnold, you may appear in the office of your lawyer that day like you've done today, or you may appear at the Butler County Judicial Center and participate from there. So that one will be a Zoom proceeding. 11:00 a.m. Tuesday, April 1. Again, jury trial set to begin the Tuesday of the following week. Court will maintain Mr. Arnold under his current bond with previous conditions remaining in effect, and the court reiterates the no contact and no communication restriction with the victim in this case, alleged victim. All right. Ms. Norris, is there anything further we need to address or readdress regarding Tyson Arnold at this time?
No, Your Honor, thank you.
Anything further at this time, Mr. Jensen?
No, thank you.
And at this time, the Tyson Arnold matter will be in recess.
Your Honor, this is gonna be Ms. Gomez. I don't have the position number.
Okay, this is position number 7, Paula Gomez. Good afternoon, Ms. Gomez. You have been charged in case 24 CR 008401J with simple battery, family violence, and willful obstruction of law enforcement officers. Is there a history, Ms. Washington?
This is the defendant's first arrest, Your Honor, and the defendant meets the criteria for UJR jail.
Thank you. Ms. Huda?
Thank you. Your Honor, this did stem from an incident on December 29th. Officers were dispatched at 3460 Kingsborough Road. Upon arrival, they met with the victim, Mr. Johnny Brooks, who said that he was trying to get his belongings out of the way. And when she grabbed him by his dreadlocks, pulling him to the floor, he said that once she let go, he called the police. He said that during the incident, his neck and his foot became injured, but there were no visible injuries to Mr. Brooks. Ms. Gomez said that when she was blocking him from coming into the room, he grabbed her by the neck and took her to the ground. Ms. Gomez stated that when he grabbed her, she grabbed him by the hair while going to the ground. Officers didn't see any visible injuries on her, but did determine that she was the primary aggressor. While she was being placed into custody, she began to resist. Officers got both handcuffs on Ms. Gomez, but she was able to get her right hand out of the handcuff. And while trying to put the handcuffs back on her, she kept pulling away, causing the officers to fall to the ground. Your Honor, we have been in touch with Mr. Brooks. He did seek treatment at urgent care for his injury, where he was diagnosed with a fractured fourth metatarsal on his foot. He has to wear a boot for 3 weeks, and he was laid off from his job due to the injury. Your Honor, due to this, we're asking for a $3,500 surety bond, $3,000 at the simple battery, $500 at the willful obstruction, a stay away from the Kingsborough Road address, and no further contact with Mr. Brooks. No drugs, alcohol, or weapons while out on bond, and we would ask that you sound for the victim at the appropriate time.
Mr. Brooks is on the line and wishes to address the court. Now is your opportunity to do so. Does not appear so. Ms. Pinto?
Thank you, Judge. Ms. Gomez is 44 years old. She's lived in Atlanta for about 20 years. She is originally from Nashville. She has 2 children, ages 5 and 22, both of whom reside with her. She's currently in college studying audio engineering, and she works as an independent contractor in the arts and hospitality industry. She does deny the allegations of being the primary aggressor. In fact, Ms. Gomez is the person who called 911. She was in the process of moving out of that location, so she is fine with the stay away. She's fine with no contact. We would just need a one-time return for her to be able to get any remaining belongings. This is the first arrest she's ever had. She's eligible for a signature bond through the jail, and we would ask the court to grant her that.
Okay, for the simple battery, it would be a $2,000 signature bond through pretrial level 1. For the obstruction, a $1,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness, no further contact with Mr. Brooks, stay away from the Kingsborough Road address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms.
Sir, I was trying to address the court. I couldn't unmute myself.
Is this Mr. Brooks?
This is Mr. Brooks.
Okay, Mr. Brooks, I will need for you to activate your camera for me.
Okay, I'm trying. Okay, can you see me?
I can see you, sir. Raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
You can place your hand down, Mr. Brooks. What would you like to tell the court?
Simply that, I just, as the attorney said, that I sustained injuries from this and I'm currently out of work due to this. I do not want any contact with Ms. Gomez at all. When the time permits for her to get her things, she can get her things, and I would like a police escort.
Okay. Thank you for being here, Mr. Brooks. Those are all things that I've already ordered, so she can have no further contact with you. No contact means absolutely no contact, no phone contact, no personal contact, no internet contact, no contact whatsoever. She can come back to the residence on one occasion with law enforcement to retrieve her belongings. So I appreciate you being here this afternoon, sir.
Thank you.
Good luck to you both.
You done. You done. Next is gonna be position number 13.
Okay. Good afternoon, Ms. Thomas. You have been charged in case 24 CR 008402A with simple battery, family violence, and battery, family violence. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's third arrest. The last arrest was in 2000 for simple battery. No disposition was listed. There was a 98 misdemeanor conviction for furnishing a person below the legal age, but the defendant does meet the criteria for level 1. Nothing further.
Thank you.
No, I've never been convicted of this crime. This is my first time ever being arrested.
Okay, Ms. Thomas, you have a right to remain silent. Anything you say can be used against you. Please let your attorney speak for you, okay?
I'm sorry.
No, you're fine, ma'am. I just want to make sure that you don't get yourself in any more trouble than what you're in right there, okay? So, yes, Ms. Huda.
So I believe perhaps Supervisor Jackson has this one, although her audio is not working right now. And so I'm not sure if she heard that this is position 13 and if she's able to participate.
And this is Ms. Jackson, are you with me?
She said if you could come back to that. She's able to text, she's having audio problems.
Okay.
I have, Your Honor, if it helps, positions 1 through 10 minus Mr. Delarm.
Norris, are you with me?
I'm right here, Your Honor.
Okay, did you hear that?
Can she repeat?
Yes, Ms. Jackson's having some problems getting on with us this afternoon. So Ms. Hudak has positions 1 through 10, except for
Mr. Delarm, I believe was.
And Your Honor,
okay.
Joshua Schiffer on behalf, I'm here for Mr. Delarm, who was arrested.
All right, we'll get Mr. Delarm out.
Okay, thank you.
All right, Delarm is over there.
Go ahead to the cell.
Go sit there.
And Judge, while they're getting Mr. Delarm, the complainant for the Delarm matter is also present on this Zoom. Miss Ruparelia is here. And
Okay.
she would be heard.
Thank you, Mr. Schiff.
Thank you, Your Honor.
Your Honor, here's position number 2, Mr. Delarm.
Yes, good afternoon, Mr. Delarm. You have been charged in case 24 CR 008406C with simple battery, family violence. Is there a history, Ms. Washington?
Your Honor, did she mention that she doesn't have him or she does?
I do not. I have.
Right.
Oh, okay. I'm sorry.
Yep, that's
So
okay.
we've got the defense attorney, but we don't have the solicitor on. So we'll need someone else, 1 through 10, except for number 2. I'm sorry, Norris.
I apologize for that.
Hey, put him back. Your Honor, here's position number 1, Mr. Darby.
Okay, thank you. Good afternoon, Mr. Darby. You have been charged in case 24 CR 008396Y with battery. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 24th arrest with multi-state interaction in Georgia and South Carolina. The last arrest was in October of this year in Clayton County for an FTA. No disposition was listed. There was an arrest in August of this year for possession of controlled substance, willful obstruction, fleeing, driving without a valid license, and a DUI, and that was out of Fayette County. That case appears to be open. In 2023, there was a felony conviction for assault and battery out of South Carolina. In 2022, there was an arrest for simple battery with Lovejoy Police Department. No disposition was listed. 2019 felony conviction for failure to stop for a blue light out of South Carolina. There are other arrests, misdemeanor convictions from 2017 related to drinking and drugs, but the defendant does meet the criteria for level 3. Nothing further.
Thank you. Yes.
Yes, Your Honor. The simple battery out of Lovejoy from 2022 was dismissed for statute of limitations issues. Otherwise, this incident did occur on December 1st of 2024. Officers were dispatched to 245 Adine Lane, where they made contact with a Miss Felicia West. And Ms. West advised that she and her boyfriend, Mr. Edward Darby, were leaving grown folks on Old National Highway when they got into a verbal dispute. She said some things to Mr. Darby that he took offense to. That's when it turned physical. She told officers that he struck her in the back of the head with a closed fist and pulled one of her braids out of her head before taking off on foot. Ms. West did advise that this is not the first time that Mr. Darby placed his hands on her. He was picked up yesterday when she called the police due to a verbal dispute between the two because of his record, Your Honor. And the fact that police had to be called to the house again. We are recommending a $4,000 surety bond. The state would recommend a stay away and no further contact. However, we did make contact with Miss Felicia West this morning, and she herself was requesting no further violent contact. And we would ask that you sound for her at the appropriate time. Also, no drugs, alcohol, or weapons.
Thank you. Ms. Felicia West is on the line and wishes to address the court. Now is your opportunity to do so. Doesn't appear so. Ms. Pinto?
Thank you, Judge. Mr. Darby is 38 years old. He's lived in Atlanta for about 6 years. He does have family here in Atlanta as well, his sister and multiple cousins. He has 7 children that he provides for, age range from 15 to 6 years old. He does have his GED. He has a good job with Techie Homes. They build tiny homes, and he's worked for them for about 2.5 years. So he does have very strong ties to the community. He's not able to pay anything for bond, Judge. So we would ask for a signature bond or as low as possible for him to have a chance to actually be able to try to post it.
Okay, it'll be a $2,000 good bond. No further contact with Ms. West. Stay away from the Adine Lane address. If necessary, he can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Darby.
What was that bond amount? Was it 2,000 or 10?
It's 2.
Thank you. All right. Next is going to be position number 4, Mr. Farmer.
Good afternoon, Mr. Farmer. You've been charged in case 24 CR. Good afternoon, sir. You've been charged in case 24 CR 008398Y with criminal trespass. Is there a history, Ms. Washington?
This is the defendant's first arrest, and he meets the criteria for UJR jail. Nothing further.
Thank you. Ms. Pinto? I'm sorry, Ms. Hudak?
Thank you, Your Honor. Police from MARTA Police Department did come across the defendant on December 30th, sleeping in the MARTA 5-Point Station despite a no trespass order valid since March 21st of 2024. Your Honor, the state's recommending a $1,500 signature bond and a stay away from MARTA 5 Points.
Ms. Pinto?
Thank you, Judge. Mr. Farmer is 48 years old. He does have one son who is grown. He's lived in Atlanta for about 3 years. He went to the 7th grade. He is eligible for the signature bond through the jail, and we would ask for that.
Ms. Pinto, does he Anything from a social worker that we can help him with, such as housing?
He didn't express that to me, Judge, whether he wanted help with that or not. But I do think that is an issue that he
Yeah.
deals with.
All right, so,
I would like to have help with like some housing, Judge.
okay, very good, Mr. Farmer. I'm happy to have someone help you with that. So I'll have a social worker come visit you so that they can explain some options to you, okay? Otherwise, it'll be $1,000 signature bond through the jail. Stay away from or abide by any minor restrictions, no drugs, alcohol, weapons while out on bond, and a social worker visit to assist. Good luck to you, Mr. Farmer.
All right, thank you.
You're welcome.
Next is going to be position number 5, Mr. Ferguson.
Good afternoon, Mr. Ferguson. You've been charged in case 24 CR 008399F with battery family violence. Is there a history, Ms. Washington?
Yes, Your Honor, this is the defendant's fourth arrest. The last arrest was in 2020 for simple battery family violence, which appears to be a misdemeanor conviction. The victim appeared to be a Desiree Jones. In 2020, the defendant completed a pretrial diversion program for theft by shoplifting, and the defendant meets the criteria for UJR jail. Nothing further.
Yes, Ms. Huda.
Thank you, Your Honor. In this instance, police were called to 5686 Deerfield Court in South Fulton on December 29th. Upon arrival, they made contact with both the defendant and the victim, Ms. Desiree Jones. At the time, Ms. Jones was completely nude on the front porch. So they separated the two. Officers spoke to Mr. Ferguson, who stated that he and his girlfriend, Ms. Jones, were in a verbal disagreement. He said that they'd been together for 5 years and he said he had video evidence of her attacking him. However, the video provided did not support his claim in the officer's opinion. The officers then spoke to Ms. Jones, and she said they verbally disagreed and that nothing transpired physically. While the officer was talking to Ms. Jones, he observed her to have a busted lip, dried blood on her nose, and a knot on the left side of her forehead. Officers then proceeded to ask her how she sustained those injuries. She stated that she has a smart mouth and that she sometimes gets disrespectful and had a bad situation going on with her boyfriend. She further denied a physical fight between her and Mr. Ferguson. She constantly denied and wouldn't explain how she got the injuries to her face. She placed blame on herself, and at times she multiply said multiple times that she was not trying to get anybody in trouble. Officers again spoke to Mr. Ferguson and asked him how she sustained the injuries on her face, and he replied she was stumbling and falling around. They noted that Mr. Ferguson had bleeding scratches on his right knuckle, blood on his palm and his left hand, and blood on his left forearm. Mr. Jones had no other visible signs of being battered. Mr. Jones also did admit to pushing Ms. Jones, but said no other physical contact was made. Your Honor, because of the prior domestic mentioned by pretrial between the two, and the behavior of Ms. Jones while speaking to officers, we're concerned about the victim's safety. The fact that this just occurred on the 29th, we are recommending a $5,000 surety bond, a no further contact with Ms. Desiree Jones, and a stay away from 5686 Deerfield Court.
Okay, if Ms. Desiree Jones is on the line and wishes to address the court, now is your opportunity. Yes, Ms. Pinto.
Thank you, Judge. Mr. Ferguson is 51 years old. He's lived in Atlanta for 8 years. He has a master's degree in nonprofit management. He has 2 jobs. He works as a disaster program manager at the Red Cross and then as the director of enforcement at the Metro Fair Housing of Atlanta. He's been at the Red Cross for 1.5 years and at the Fair Housing nonprofit for 2 years. He and the alleged victim do not reside together. Mr. Ferguson denies the state's version of the facts. And he was actually the one who called law enforcement. He is okay with no contact. However, I think the incident location, please correct me if I'm wrong, Mr. Ferguson, but the Deerfield Court, I think that's his address. So we would ask that he be able to return to his own home. And it's my understanding that Miss Jones does not reside there. But he is happy to have no contact with her if ordered by the court. He's eligible for the signature bond, and we ask the court to set that.
Okay, it will be a $5,000 signature bond through pretrial level 2, 1-day anger awareness, no further contact with Desiree Jones, no drugs, alcohol, weapons while out on bond. If Miss Desiree Jones does not live at the Deerfield Court address, he certainly can go back there. But if she does reside there, then he cannot go back there. So if he's telling us that she doesn't reside there, then I'm going to allow him to go back there. But if she does, and given that he can have no contact, he's going to have to get his belongings and find somewhere else to reside.
Yes.
All right. Good luck to you, Mr. Ferguson. Ms. Hudak, while we're, would you mind inquiring of Ms. Jackson to get on with another device, or just to make sure we get to the end of your case that we're able to
Miss Sears, yeah, Miss Sears is on and ready to go. She is my counterpart today.
Oh, okay. Thank you.
Good
Good
afternoon, Your
afternoon. Afternoon, Ms. Sears. All right,
Your
so
Honor.
I think everybody's on that we need.
Okay.
Okay, so just let us know where you want to go.
We're gonna go to position number 8, Mr. Griffin. He said that he has private counsel, but I'm not sure.
I think someone's on for him.
Judge, this is David Rigdon. I'm here on that case.
Afternoon, Mr. Rigdon.
Afternoon, Judge.
Good afternoon, Mr. Griffin. You have been charged in case 24 CR 008403G with battery family violence. Is there a history, Ms. Washington?
Yes, Your Honor. This is the defendant's 11th arrest with multi-state interaction in Florida and in Georgia. The last arrest was in 2014 for wire fraud, which resulted in a felony conviction. In 2009, there was a felony conviction for trafficking drugs out of Florida, and the defendant does meet the criteria for UJR jail. Nothing further.
Yes, Ms. Hudak.
Yes, Your Honor. So on December 15th of 2024, officers were called to 600 Phipps Boulevard, apartment 2118 in Atlanta, where they spoke to the victim in this case, Miss Vifalia Barao Mateo. Officers were told that she was awoken by the defendant at approximately 2 a.m. when he entered her house without permission and demanded sex. She told him to leave, and a verbal fight ensued. He ultimately pulled on her clothing and punched her multiple times in the face. Officers did observe bruising to her lower lip. She later, we spoke to her this morning, Your Honor. She did provide us medical documentation that indicated that she has 3 loose teeth from the strikes to her face that need replantation. She doesn't have the money right now to pay for that treatment. However, that was ordered in the diagnosis and the treatment recommendation. She also sought a 12-month protective order via Gwinnett County from the defendant, and that was granted. Your Honor, because of the damages to our victim, the Solicitor General's office is going to seek to take this case to the district attorney's office. However, in the meantime, we are asking for a $10,000 surety bond, a stay away from the address, no further contact with our victim, no drugs, alcohol, or weapons, Your Honor. This is based on not only her injuries, but the fact that he went into her home without permission and attacked her. Thank you.
Ms. Mateo, if you're on the line and wish to address the court, now is your opportunity to do so. If you choose to, I'll need for you to unmute yourself, and I'll have to swear you in.
Hi, good afternoon, Your Honor, and all those who are present.
Good afternoon, Ms. Mateo. First of all, I'm going to, Ms. Mateo, first of all, I'm going to need for you to stop walking, okay?
Okay.
All right, so find a steady state place for me.
Okay.
Okay, I need for you to raise your right hand.
No problem.
Do you swear? That's how you're fine.
I'm trying to just get this in order. Okay,
Okay, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
I do think that I was shocked to see the charges that were given to Elder Griffin. I don't think that battery suffices what actually happened. He broke into my apartment. I left several months ago to avoid this relationship, to leave this relationship. This is about my fourth attempt to leave this relationship. Um, he came into my apartment. He charmed his way up. I'm in a high security skyrise, but he parked in the front with the intentions of being there for a short time to get his vengeance because he was rejected, to try again, and ended up not only just breaking in, but also stealing my property, putting his hands on me. I wasn't just left with scratches and bruises. I have three of my front teeth are still loose from the root. I don't have health insurance given that I moved to Georgia from New York City for this man about 2 years ago. And I've never really, gotten health insurance. I can't afford to get the dental work that I do need right now. All those things were documented. He also stole, my driver's license, the one from New York, the one from Georgia, including the 3 different credit cards that were in that wallet. My car's registration documents were also stolen. My dog, Macho, was stolen. And he also agreed, he signed on the paper for the protective order to return Macho after he stole him. There's also surveillance. There were 6 people present during the time virtually. I was on FaceTime with a support group with women who have also dealt with domestic violence and these things. That's why I'm a part of this group. They witnessed it. The time is according to the time that he broke in. So we were on this call for about an hour before he broke in, up until like maybe an hour after the cops came and left. So they witnessed the entire thing. I just think that battery as a charge is insufficient. I do fear for my life. We have spoken, the reason why I've never called the police, we have spoken about his very long criminal history, and that if I call the police, that I'm taking him away as a father from his children, who I love dearly, and I have treated as my own kids throughout this almost 3-year relationship. Now I'm seeking justice, and I do fear. I mean, I was put on leave from my job. I have not been able to afford to just survive and pay my bills because I'm on leave from work. I was just allowed to come back to work. I'm a med tech and a assistant nurse at a assisted living facility for people with memory care. They offered to have extra security and police officers present because of the situation, because it's not the first time I've called out because of an instance of this. This is a long record of me calling out or whatever because of our discrepancies when we were together. He does not like me being independently, financially independent, or living my own life, or rejecting him in any kind of way. I just cannot understand me pursuing my life and the things that I got going in a state that I don't have any family or anything, and feeling safe while he's out. And we've talked about it. He doesn't want to go back to jail. Him going back to jail, he would prefer someone's life being ended or him leaving or him fleeing the country. Hence why he's made a whole appointment to get a new passport for him to leave the country. He's a flight risk. He has an appointment on the 3rd of January to get a new passport because he's going to flee the country, or he's going to hurt me, either or. And I have proof of anything and everything. And the fact that there's surveillance of him coming into my apartment during this time without any permission. I never went downstairs. I even sent him a message saying, listen, if you're inebriated, if you're drunk, you go to your sister's house, but don't come here. And he ended up coming here, and they all heard. I don't know. I was told.
Ms.
I'm
Mateo,
sorry. I don't mean to get emotional. And
no,
excuse me.
I understand. I understand.
Excuse me. Excuse me. I'll pause.
I just don't, no, you're fine. You're fine. I'm sure that the solicitors, victim advocate will be getting in touch with you along with the solicitors based on what you've said this afternoon. This is just a bond hearing this afternoon, but I do appreciate you being here this afternoon, okay? All right, thank you, ma'am. Yes, Mr. Rigdon.
Good afternoon, Judge. Just to add a little bit of context here, I know that this is not our time to introduce evidence, but there's substantial evidence that these fabrications have been, well, that these allegations have been fabricated. I believe my client was previously trying to take a TPO out on her because of a prior false police report. And I believe the dog in question was actually his dog. And he was told that he could get the dog back, Judge. So, I mean, we really are looking forward to getting into this more deeply and using some of the evidence we have. But then again, I know that today is not the time for that. So my client lives in the greater Atlanta metro area. He has 3 children. He owns his own business that I believe is some type of concrete cutting business. Judge, he hasn't been in trouble in years at this point, and I believe he's a changed man. So we would just ask you to give him a cheap bond, whatever you deem as fit, but I don't think you're going to have any more trouble out of Mr. Griffin. Thank you.
Okay, I want to have Mr. Griffin monitored, so I am going to send him through pretrial. It will be a $10,000 signature bond through pretrial level 4, 1-day anger awareness, no further contact with Ms. Mateo, stay away from the Phipps Boulevard address or wherever she resides, no drugs, alcohol, or weapons while out on bond. Let me make it very clear what stay away means. It means no contact whatsoever. No phone contact, obviously no personal contact, no internet contact, no email contact, absolutely no contact. If you violate that portion of my bond, then it's going to be withdrawn. Okay?
Yes, sir.
All right. Good luck to you all.
Judge, that'll conclude my business. I may be excused.
Yes, Mr. Riggin, you have a good
Your Honor,
safe holiday. Yes, ma'am.
excuse me, does that include harassment from his family members to drop the charges against him?
He cannot have anyone, he cannot contact you or have anyone contact you.
Even if
Okay?
it's been within the time that he's been arrested, I've been harassed by his son and his other baby mothers and things.
Okay, well, he's hearing me now, so he hasn't been in front of me, so he understands, and through Mr. Rigdon, his attorney, that he can have no contact with you and that his family members can't have any contact with you.
Okay,
Okay?
thank you. Thank you, Your
You're
Honor.
welcome, ma'am. You're welcome. All right, good luck to you all.
Thank you. Thomas. Ms. Thomas. Your Honor, we're gonna go back to position number 13, Ms. Thomas.
Okay.
That's my case, Your Honor.
All right, and Ms. Thomas, I've already advised you, but let me do it again of what you've been charged with in case 24 CR 0084002A with simple battery family violence and battery family violence. It's my understanding that there was also a 2000 simple battery and a charge in 1998, and those were the only charges, I believe. Is that correct?
Yes, Your Honor. That was the third arrest.
Okay, thank you. Yes, good afternoon, Ms. Sears.
Yes, Your Honor. So the facts of this case are alleged as follows. The location is 3198 Washington Road, apartment 20. That's in East Point, Georgia, where the victim, Lakita Thomas, resides. I believe Ms. Thomas may be on the call this afternoon. Ms. Thomas and the victim, Lakita Thomas, are mother and daughter. The victim alleges that defendant pushed her and pulled her during a physical attack, causing some of her hair to come out, as well as a laceration to her wrist. When police responded to the location, they observed those injuries. The defendant did corroborate the victim's account that the victim, Lakita Thomas, was pushed into a grill, which is what caused the laceration to her wrist. And thereafter, police placed Miss Veronica Thomas under arrest. Despite the familial relationship, the victim, Miss Thomas, does not want any contact. She does want to allow a one-time law enforcement escort to the residence at the previously provided address so that she can retrieve her belongings. a $2,000 signature bond, a complete and total stay away from the incident location, no drugs, alcohol, or weapons while on bond.
Thank you. Ms. Kim, good afternoon.
Good afternoon, Your Honor. We have no objection to signature on bond. My client wants to have a contact with her daughter. I believe that there's a lot of misunderstanding, and because she's the one who's taking care of her daughter's grandchildren. I mean, not her daughter's grandchildren, but her grandchildren. But she doesn't mind honoring those wishes either.
Okay, for the simple battery, it'll be $1,000 signature bond through pretrial level 1. For the battery, a $2,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. No further contact with Ms. Thomas. Stay away from the Washington Road address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Thomas.
All right, thank you, Your Honor.
Your Honor, what was our bond amount again? I'm sorry.
No, you're fine. A total of $3,000 signature bond through pretrial level 1.
Thank you.
Welcome.
You done. What's the number 12? Delarm. This is going to be position number 2, Mr. Delarm.
Yes, good afternoon again, Mr. Delarm. You have been charged in case 24 CR 008406C with simple battery family violence. Is there a history?
Yes, Your Honor, this is the defendant's second arrest. The last arrest was in 96 for terroristic threat. No disposition was listed, and the defendant meets the criteria for UJR jail. Nothing further.
Your Honor, on behalf of my client, we would ask for. Sorry.
Okay, hold on, Mr. Schiffer. The way I normally do this is I allow the state to go first so that I can understand what the facts are, and then I'll allow you to follow up, okay?
Yes, Judge.
All right, very good, thank you. Whose case is this?
It's
your
Ms.
case,
Sears' case. Number 2, position number 2, Mr. Delarm.
Yes. Sears, is this your case? If so, you're on mute with us.
I did not realize I was on mute. So
Okay,
sorry.
no, you're fine. Go ahead.
Your Honor, the facts as alleged in this case are as follows. On or about December 30th, 2024 at the 815 Kinley Walk, Roswell, Georgia address, defendant and his wife, Miss Irvi Ruparelia, who is on the call, were involved in a verbal dispute, which turned physical when the defendant pushed through a door that the victim was on the other side of and attempting to keep him out of the room where she was. He pushed through that door, causing the door to break and causing Miss Ruparelia to fall to the ground. Police responded to the location and placed Mr. Delarm under arrest, charging him with simple battery family violence. This particular case, I would ask that Your Honor hear directly from the victim, Ms. Ruparelli, regarding contact. We're asking for a $2,000 signature bond, no drugs, alcohol or weapons, and that he stay away from the incident location at 815 Kinley Walk.
Yes, good afternoon, Ms. Ruparelli. If you'd like to address the court, you'll have to unmute yourself for me. Raise your right hand. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
I would like my husband to be able to come home. I would like full contact, and I do feel safe with him.
This has not happened before?
No.
And you're not afraid of him?
I'm not afraid of him.
Okay, thank you for being here this afternoon, ma'am. Yes, Mr. Schiffer.
Your Honor, we would ask that the court approve the state's suggested $2,000 signature bond. We would ask that if any special condition be granted by this court, that it just be no further violent contact, as the putative complainant has indicated unambiguously to the court that she's not in fear of the accused and wishes him to be present at their home. They have been together for literally almost 20 years. They work together. They've gone through a lot. I don't believe that this incident is reflectant of their relationship in any way, and I expect a rapid and speedy resolution. Other than that, we have nothing else to add.
Okay, thank you. It'll be a $2,000 signature bond through pretrial level 1 day anger awareness, no further violent contact with Ms. Ruparelia, and no drugs, alcohol, or weapons while out on bond. Good luck to you all.
Thank you, Judge. Judge, that concludes my business as well as Ms. Ruparelli. May we please be excused?
Yes, have a good afternoon. Happy New Year. Be safe.
Thank you, Judge. Good to see you, sir. Good to see everybody else as well, and have a happy New Year, everyone.
Thank you.
Thank you.
Okay, who do we have?
Alpharetta coming on the line now.
Okay.
Are we gonna go to Alpharetta now, Your Honor?
Wherever you want me to go, Norris. I don't see them.
I can't see if Alpharetta's on.
Okay, I don't see them on, but
They're coming on. It's taking slow. I'm sorry, y'all. I don't have control of the internet.
So, in the meantime, Your Honor, we're gonna go to the add-on, position number 1, Ms. Lee.
okay.
No,
Good afternoon, Ms. Lee. You have been charged in case 24 CR 008409H with 2 counts of simple assault. Is there a history, Ms. Washington?
This is the defendant's third arrest with multi-state interaction in Georgia and Arizona. The last arrest was in July of this year for theft by shoplifting and battery out of Bibb County. It appears that the defendant is completing the pretrial diversion program for that case. In 2021, there was an arrest for assault in Arizona, which appeared to be dismissed. The defendant meets the criteria for UJR jail. Nothing further.
So we would like request for a UJRJ, but I'm gonna let solicitor go first.
Yes.
Facts in this case are as follows. These events alleged to have occurred December 29, 2024 at a hotel at 3400 Creek Point Drive in East Point, Georgia, where the defendant was asked to leave the location by hotel security and staff and became belligerent. As she was being escorted from the premises, she produced a can of pepper spray and discharged it in the direction of the security guard and the staff member, causing that pepper spray to come in contact with two people. We are asking that she stay completely away from the incident location, and that when she's released, it's on a $2,000 signature bond, and that she have no drugs, alcohol, or weapons. And that is all. That is all from the state.
Ms. Kim?
We have no objection, Your Honor.
Okay, for each charge, it'll be a $1,000 signature bond through pretrial level 1, makes for a total of a $2,000 signature bond through pretrial level 1. Stay away from the Creek Point Drive address, and no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Lee.
Thank you.
You're welcome. Who do we have at the Alpharetta jail?
That should be Andrew McLean.
That's my case, Judge.
Okay. This is add-on 2, it looks like. Good afternoon, Mr. McLean. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of an attorney this afternoon if you do not have a private attorney. Mr. McLean, you've been charged in case 24 CR 008408C with simple battery. Is there a history, Ms. Washington?
Your Honor, this is the defendant's first arrest, and he meets the criteria for UJR jail. Nothing further.
Judge, that's my.
Okay, yes, good afternoon, Mr. Murphy. Let's see. Ms. Hudak, yes.
Thank you, Your Honor. Yes, in this instance, officers from the Alpharetta Police were responded to 300 Avalon Boulevard, which is the Crew Food and Wine Bar. On the 30th of December, upon arrival, they spoke to Juan Mesa Orozco, who told the officer they were struck in the face by an unknown man. Essentially, excuse me, Your Honor. Mr. Orozco and Mr. McLean initially began arguing back and forth about football. When Mr. McLean became upset and told him to meet him outside so they could fight, the victim declined the opportunity to go outside with Mr. McLean. He did come back into the restaurant to apologize, but when he came back into the restaurant, he apologized and slapped Mr. Orozco across the face without provocation. Your Honor, we are asking for a $1,500 signature bond, no further contact with Mr. Juan Mesa Orozco, that's Orozco, and a stay away from the Crew Food and Wine Bar, and that's CRU, Crew Food and Wine Bar.
If Mr. Orozco is on the line and wishes to address the court, now is your opportunity. Yes, Mr. Murphy.
Judge, this was stranger to stranger contact. They do not work together. They do not know each other. My client's age 34. He does reside in Georgia. He's a single parent. The facts are a little different. My client asserts that he was there with his daughter, and this gentleman was having interactions with him, and he did not approve of it. He is employed in Georgia. He'll honor the conditions of the bond. He has no prior history whatsoever. We'd ask that you allow him the signature bond. And again, he'll stay away from the location. He does not work there. He's in the restaurant industry, but he's not working that restaurant.
Okay, it'll be a $2,000 signature bond through the jail. No further contact with Mr. Orozco. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. McLean. Thank you, Mr. Murphy. You have any other business this afternoon?
That's it. I may see you Thursday on something else. Thank you, Judge.
All right. Happy New Year. See you next time.